I cannot show any permission. But there are members in my union who have been there selling tea or jhalmuri malad for 40, 50 years or maybe more, uninterrupted, unabated by the railway authorities. And a junior must have placed the notice. In their eyes, I may be an unauthorized occupant occupying a public land, or I may be a trespasser under the Railways Act section 142, probably my learned 147, my learned senior will place. Well, nothing is mentioned in the notice because these statutes give me some statutory remedies as well, and these are meant for unauthorized occupants. If at all I'm an occupant, whether I've accrued any right or not, by being there for a certain period of time, adjudicated by someone, I cannot be thrown out of my livelihood. My 2 square meals, my child's education depends on this. I cannot be merely by pasting a notice. I cannot be thrown out like a swatting a fly. And my only contention here is that if anything was mentioned in that notice, my members or me as a union could have taken a step.
Who is the writ petitioner?
A trade union.
And for member also.
First is the trade union and thereafter the
And is it a registered union?
registered trade union.
Letterhead আছে, page 22, registration number আছে.
Now, my lord, within such a short span, we had to come before Lochi Malad. We have sought leave before Lochi Malad. We could not make a representation also. But even making the representation today, I do not know under what law they will take this step.
Very
But
well.
like in a private office, suddenly by order of management, something is pasted. That do not eat here, do not sit here. That cannot be the system. Kindly, these people are there for 50, 60, 70 years. Kindly seize my list at page 25.
94 persons.
94 persons, but rather, can you see serial number 11 is there for 40 years. Serial number 17 is there for 50 years, selling garments. Serial number 11 is selling tea. Serial number 12 is selling jhalmuri for 40 years. 18 is there for 50 years. 19 is there, serial number 19 at page 26 is there for 60 years.
Very well. Let me hear.
But firstly, the question involved in this litigation is covered by several judgments for the last 10 years. Even the point of law which is being raised. Now, the first question is that they are not aware of this notice, the general notice, but if you lost, you kindly find from the annexure. They were aware of the notice, the association took a resolution to move the on. Number 2. Number 2 is that for running any business, either hawking or otherwise, especially in this category of selling tea and others, there are 2 licenses. One is the general license and the other is the food license. So the question of adulteration of supply of products. Nothing is there on instruction and so on. Absolute unauthorized. Now, this writ petition is a general statement. Only my learned friend has not argued. I am answering that question. They have resorted to 1971 eviction of unauthorized occupants. That question has also been decided by the division bench because this will not apply. Firstly, the 71 Act is a general law and this is a special provision. Now, this question has been time and again decided by this honorable court. Kindly see once in the list, section 147(2), which has been declared inter pares by this honorable court. 147(2) of the Railways Act, I hand over.
Where is it?
Yes, kindly see. This question was considered. I shall be placing all the judgment and the latest judgment of the division bench Johnson. I had the privilege to appear. 147(2). This is a special provision acted by the Parliament.
Yes.
That apart, this eviction drive is being taken now for the Government of India's Amrit Bharat scheme for renovation of the platforms and the railway stations and all that. That is the Honorable Prime Minister's decision and that is being done. Now, my learned friend has relied on some paragraphs, but the question is that they have stated on oath, the false statement that they had a license. No license was ever issued.
Where is the license?
Nothing is disclosed.
Where is it mentioned that they have a license?
Para 8, page 6.
to renew their licenses.
Where is the license?
All right.
Hardly, simpliciter prayer in prayer C is to make a representation for grant of license. It's not a prayer for renewal of license. Prayer C. Then comes the question that your last will kindly allow me to see that whenever is a well settled principle of law, whenever there is a conflict between national interest and the individual interest, the national interest shall prevail. The national interest to reconstruct and initiate a project of the government of India. Now I am placing before your lordship the judgments. This is the reported judgment of the division bench. This is I'm sorry, this is single bench judgment of my lord Mr. Sanjeev Banerjee as lordship claim was. Considering all aspects of this matter, including the applicability of the Eviction of Unauthorized Occupants Act. And kindly see, I am not taking so much of your lordship's time. What is the conclusion of the judgment? At the last two paragraphs, any action.
Last two paragraphs. Any action?
Any action taken by the state to evict a person from the property is justiciable.
Mm.
The right to evict a person who has lawfully entered into upon a railway property arises only upon such persons refusing the property or refusing to live thereupon. The refusal to live would arise if the person has no right to remain on the railway property. It is possible in a given case for a person evicted from the railway property upon the railways resorting to section 147 of the Railways Act to assert and establish that there was no obligation on such person's part to leave the railway property. If it is found in the appropriate action that a lawful entrant into railway property had been unlawfully removed therefrom, the appropriate forum will be due authority to restore the possession of such person. In the present case, there is no justification which is proffered for the petitioner to remain on the railway property up to the expiry of the lease. Since there is no illegality or arbitrariness found in the railway resorting to section 147 of the Act, to evict the petitioner from the railway property is dismissed. Now there is another judgment.
Here, possibly, or not possibly, the petitioner must be having some license, lease, but the judgment that you are
Now there is no lease.
nothing of the sort.
Nothing. And the only question which was raised before the others in honorable judge, that a person shall be evicted by due process of law and the opportunity of it. My lord, Mr. Devanshu Bashar had to to hold. Principle of natural justice does not mean giving an opportunity of hearing whether you are to defend that you are in lawful possession or not. Then the question comes of eviction tried by due process of law. My lord, should I press that?
Yes, please.
All such questions were argued. এটা কোনটা এই কপি দাও না দেখে একটাও দিচ্ছিল না কপি তো সুব্রত ঘোষ kindly come. There are so many judgments referred to by both sides about this issue of due process of law and all that. Kindly allow me to start from. I did not repeat the judgments referred to, but I am just reading the conclusion. Kindly come to last part 1 page, last part 2 pages of the judgment. On the top, I will read. A licensee subject to the revocation of such license can be evicted. Have you got it?
Yes, I've read it.
The eviction, however, has to be in due course of law. But due course of law, one understands that the process by which a person who has entered into the premises lawfully as a licensee and upon termination of such license stands as a trespasser is evicted by a method recognized by law. If there is a statute governing the process of eviction, then due course of law will mean that possession can be recovered by taking recourse to such statute. According to the petitioner, the Act of 71 operates in the field, and that section 147 of the Act of 89 has no manner of application. The interplay between section 147 of the Act of 89 and the provisions of the Act 71 has been considered in such case. Therefore, both the honorable judges have been pleased to consider and hold the 71 Act has no manner of application. And Lord, I shall clearly submit that another matter, which is the latest one, which was argued with the learned single judge. Here, the cooperative society on the similar issue raised an issue that they are given a notice, but hearing is not given. The learned single judge has been pleased to hold that 147 will apply. The Subrata Ghosh's judgment was considered, but wanted that they should be given a notice, and thereafter on a decision they can be evicted. This is, my lord, চন্দননগর স্টেশন এরিয়া স্টোরকে সব বলে দিচ্ছেন।
চন্দননগরটা আমি জানি। আচ্ছা, এটা তো দেখতে পাই। এটা অ্যাপিল হয়েছে তো, অ্যাপিলটা
Appeal দিচ্ছি, and appeal was referred, and the appeal court has affirmed the judgment, giving some time for their eviction. This is the appeal court judgment. I had the privilege to attend.
Well, what are you proposing to do? You want the eviction to be today, or you want to
No,
give
I
them
have
an
no objection if your lordship kindly gives them some time. But
some time to move out?
yes, because that will cover everything. Because the question simplicity is whether they have a right to remain in possession. These are my suggestions. Now, should I hand over the division bench judgment affirming the order? Already handed over to it. Division bench of the Honorable Chief Justice.
in Chandanagar, my lord,
This is a single bench judgment.
yes, it traveled to division bench. my lord.
Whatever, it has been affirmed.
It has been affirmed. But
Ah.
in this, my lord, they got the hearing.
Oh, the
These
division bench
persons
is
got the hearing. And the hearing, my lord, they could not satisfy the authorities. In our case, I started with this point, my lord. This 147 is also not mentioned. What power they are exercising is not mentioned. It is not that, my lord, I am.
That is where is your right?
my lord,
Any
I-
license?
I cannot show a license. I cannot show a permission. But I am there, my lord, for 40, 50 years. It is not that today suddenly I am coming today and loitering in the platform.
Then your
service for
submission for renewal of license is absolutely indifferent.
some members. My lord, here are trade union is before.
Show me one member who has a license.
Huh? But some time has to be given because my lord, this is long time back. My lord.
Assuming there was a license long time back, it was never
Well,
renewed.
let them at least hear one representative of us on behalf of everyone. Well, at the cost of reputation, my lord, I am making this submission, not that I am there without a ticket. I am trespasser, my lord, encompasses a lot many things in 147(2). Some destitute is staying there for 2 nights, 3 nights, 4 nights, 1 week.
You are not representing the destitute.
No, that is
No,
what I'm saying.
let them not go to
147(2)
that.
encompasses many things. But I am there for 40, 50 years. And in that Chandanagar station area of hawkers matter, my lord, appropriate hearing was given to them. They could not satisfy. And thereafter, her ladyship came to the finding that they are admittedly they are trespassers at paragraph 19 bottom.
Tell me who would be the competent authority to hear them?
No, I think it's sufficient.
The DRM?
DRM Howrah. Yes, DRM Howrah.
DRM?
This one of 4. This one of 4.
Yes, please come.
Lord, may I give?
Yes. The petitioners. Now, the petitioner number 1 is a registered trade union, and the petitioner number 2 is its secretary. Stop. The petitioners claim that the members of the petitioner number 1 are hawkers who carry on trade and business for years together in and around the Srirampur railway station. Stop. The railway published a notice mentioning that eviction of the unauthorized encroachments will be held, encroachments at Srirampur platform and its circulating area will be held on 27th February 2025. Stop. The unauthorized occupants have been requested to vacate their position by 27th February 2025, failing which action will be taken against them. Stop. Paragraph. The petitioners submit that since they are occupying the said place for years together and they are running their livelihood from the earnings therefrom, they should be provided an opportunity of hearing prior to taking any coercive step against them. Stop. Paragraph. Learned ASGI opposes the prayer of the petitioners. Stop. reliance has been placed on section 147 of the Railways Act, 1989, and several judgments delivered by this court on similar points of law. Stop paragraph. It has been brought to the notice of the court that the eviction drive has been started in respect of a project dash the Amrit Bharat scheme dash. Stop. The national interest is involved, and accordingly the same will prevail over any personal interest of an individual. Stop paragraph. Prior to deciding the matter on merits, the court grants one opportunity to the petitioners to produce documents in support of running their business from the railway land. Stop paragraph. The respondent number 4, the divisional railway manager, Howrah division, Eastern Railway, is directed to afford an opportunity of hearing to one of the representative of the petitioners.
Let it be petitioner number 2 who claims to the secretary.
আচ্ছা ঠিক আছে, petitioner number 2. Petitioner number 2.
যদি ভালো বলতে না পারে
Let it be our representative, Malad. I do not know whether petitioner number can articulate the point before a manager, DRM,
আচ্ছা, ঠিক আছে।
senior officer, Malad.
The petitioner number 2, who may be assisted by a legal representative. ঠিক আছে, stop. Next. The matter is made returnable on 12th of March.
Malad, maybe a day thereafter, Malad.
13th.
13th, Malad. 13th.
ঠিক আছে, 13th. The fate of the hearing shall be made known on the adjourned date. Stop. Notice of hearing may be served on the learned advocate on record of the petitioner. So it will be easy for both the parties. ঠিক আছে, stop.
অ্যাডভোকেট রেকর্ডকে নোটিশ দেবে
Very well. Come back.
13th.